Yes, I have a revocable living trust that was written, I think, back in 2005.
Okay.
And I was told that if I have written anything in the margins or anything, that the entire trust is voided. Is that correct?
No. Who said that?
I don't know. I got an opinion from an attorney that I don't have a great deal of faith in, but that's what she said. She said if there's any writing in it that the courts have ruled that the entire trust is invalid and everything gets thrown into probate.
Well, no. I mean, first of all, no. But secondly, I mean, people pen and ink changes in trusts all the time. They go through, and with a will, not a trust, but with a will, you can obliterate. In other words, you can X stuff out, but you can't write stuff in. That's the basic rule. Okay, you can obliterate, but you can't add to it. Okay, that's been sort of a rule of construction. With trusts, it's different. You see, one of the nice things, one of the features of trusts is that they are so flexible. I mean, you can have a trust without any writing at all. All right, you can have a trust that arises from the operation, the relationship of the parties, just the way you've been dealing with each other. You can have a verbal trust and what we call an express trust, meaning you actually said it. So you wrote it down, you said it, that kind of thing. That's an express trust. And then you can have an implied trust. And then you can have a trust that's imposed by the court. So there's all kinds of ways. We recently did one where it was a couple was traveling to a foreign country, and it was in the magazine for the foreign country that they wrote a bunch of stuff, and we managed to get that enforced. Now, it doesn't void the trust. It doesn't throw out the trust. It doesn't make the trust unenforceable. You might have to go to probate if there's an argument. See, if people are going to fight about it, right? Probate court is where you go to fight. But they can fight over They can fight over a printed trust. The fact that you now.
Go
ahead.
What happened is I had someone in my trust who has passed away, so I just crossed their name out because they're dead anyway. They've already achieved room temperature. Nothing is going to happen.
Right.
And so.
Well, here's the thing with that. If it was a child, right, the presumption is that if a child dies, then whether or not you said it, that the assets are the distribution to the child would now go to the child's children. It would follow the bloodline.
Right.
So by obliterating the child's name without disinheriting the kids, you do open yourself up to a challenge from those children, against it. So you want to, because the next thing I was going to say, it doesn't void it. I mean, it doesn't say, there's no good at all. We're just going to throw it out. No, that doesn't happen. But there are lots of ways to mess this up, okay? And simply doing it yourself is, look, it's probably not the best bet. Right?